can be difficult to find an attorney to bring your case on a contingency fee basis. Why is that? Hi, I'm Tom Spiggle with the Spiggle Law Firm. We help people who've been fired or afraid they might be in Virginia, Maryland, and Washington, D.C. So you've seen the billboards, you've seen the advertisements, you got a phone, you got a lawyer, we don't get paid unless you do. These are often in personal injury, car crash kind of cases. So that is a contingency fee arrangement. The attorney only gets paid if there is a favorable verdict or settlement. You don't see that as often in employment law cases, and there are three reasons for that. Number one, there are caps in employment law cases that make it less valuable. Many of these were set in the early 1990s, and they haven't been raised since. So even if you take it all the way to trial and ring the bell, you can often win less than you could in a comparable personal injury case. The second reason is that many employment law cases have to be brought in federal court by nature of the claims, or depending on what kind of state you're in. In federal court, there's a much greater likelihood that employees lose on summary judgment. It's expensive to get there, and many times if you lose, it can mean the end of your case. In contrast, in personal injury matters, these are often brought in state court. And in state court, there's less of a risk of summary judgment, and it's often either you're settling the case or you're going to trial, and many defendants just simply don't want to try the case, so they'd rather settle. And finally, an employment law is complicated. It can involve federal law, state law, local ordinance, Supreme Court precedents, you name it. So it tends to be difficult cases to bring. In contrast, personal injury cases tend to be brought in state court and involve a similar set of laws. Now, understand me, I'm not saying personal injury is an easy practice area. Those guys work really hard and do great work. But the truth is that the way that practice is, a contingency fee is much more manageable there and is a decent business model, whereas in employment law, it tends to be less common. Now, that doesn't mean you can't find contingency fee arrangement. There are attorneys who do that, and it tends to be more prevalent in certain states. I'm thinking California, the New York City area, New Jersey, perhaps Washington, D.C., you will see more contingency fee arrangements because the laws are more employee friendly. Other kinds of claims like wage and hour class action cases, some whistleblower cases, you're going to be more likely to see contingency fee arrangements. But in your basic discrimination kind of context, it can be difficult to find an attorney to take your case on contingency for the reasons that I just mentioned. That doesn't mean it's not worth looking, but don't feel like there's a problem with your case if you're having a hard time finding someone. Hope that helps. If you want more information on employment law, you can go to our website, spigglelaw.com. In the meantime, best of luck out there.